A lot of people run into a situation with their landlords where something is going wrong with the property that the landlord might be responsible for fixing or providing. Maybe there's something wrong with one of the systems or utilities. Maybe there's something wrong with the roof or something that is now causing a leak that's causing damage onto the property. Whatever's going on, many times there are some pretty significant issues that come up. And the question arises, when can a tenant actually withhold rent? I get this question pretty frequently in my practice, where a tenant will call about a problem they're having. They've told the landlord, hey, you have to fix this thing. It's written out in the lease pretty clearly that this is landlord's responsibility, but they're not doing it for whatever reason, or they're being really slow to do it. So then the tenant asks, can I withhold rent? And the thing is, it is extremely rare that you can actually withhold rent, or at least it's much more rare than a person might think in many cases, because the lease says right there, hey, the landlord has to do this. But typically, if you're going to get to the level of withholding rent, there's a lot of steps that have to be met, or at the very least, it's a pretty high standard to actually meet, even if it might seem pretty serious at first glance. Now, let's just take a look at Texas, for example. I'm on the Attorney General site. It says right here, you do not have a right to withhold rent because the landlord fails to make repairs when the condition needing repair does not materially affect your physical health or safety. And that actually specifically, if you go over to the Texas Property Code, it is the material. It's when it materially affects the health and safety of an ordinary tenant. So even if you're of ill health, or if the person in the property is of ill health, and if the temperature is rising in the unit, it happens a lot here in Texas in the summer. If the AC goes down and now it's 85 degrees in the house, does that materially affect the health and safety of a person who maybe is of ill health? Maybe so, you can make that argument, but the statute says for an ordinary tenant. So does an ordinary tenant have health problems? Probably not. So therefore, the standard probably isn't met there to withhold rent. Doesn't mean that you don't have recourse against the landlord necessarily, but oftentimes it does not mean that you can just withhold rent, or at least there is a pretty significant risk that you'll be penalized for it. At least in Texas, the code lays out some pretty serious remedies for a landlord against a tenant who wrongfully withholds rent. And of course, every area might be a bit different. Every state, every county, every city might have its own standard for when a tenant can withhold rent. So you definitely want to look at those very closely and apply the facts of your specific case to the specific law that affects you in your area. So you want to be very careful when you do that. Really, you just want to be careful whenever you're dealing with any sort of dispute with a landlord. You may feel like you're entitled to do something. Just want to make sure that you're actually allowed to, because even if it might feel right or seem right, sometimes the law is not on your side, but you may still have recourse in other areas. And to my landlords out there, be sure you're actually following the rules and the obligations set under the lease, because if you don't, you could be in for some serious pain. Even if a tenant might not be able to withhold rent today, doesn't mean they don't have recourse tomorrow. And consider consulting with an attorney if you're unsure about your specific situation. Whatever the case, if you found this video helpful, please let me know, and I'll see you in the next one.